Start. Learned counsel for the appellants highlighted as to how the judgment of the High Court suffers from various infirmities, both faculty and on principle of law. None appears for the respondent, though she was represented by a counsel who did not appear on several dates of hearing and also is not present today. The High Court recorded findings to the effect that there were no specific averments in the pleadings, that the plaintiff was ready and willing to perform his part of the contract, and also no evidence was adduced in this regard. As rightly pointed out by learned counsel for the appellants, the findings are contrary to the materials on record. As noted by the first appellate court in various paragraphs of the plaint, more particularly paragraphs 18 and 22, specific averments regarding readiness and willingness of the plaintiff to perform his part of the contract have been made. Additionally, the plaintiff, who was examined as PW9, has categorically stated that he had gone to tender the money, that is, the consideration, to the defendant, who was not agreeable to return the sale deeds, and therefore the only course left open to the plaintiff was to file a suit. On this ground alone, the judgment of the High Court is vulnerable. Another factor which appears to have weighed with the High Court is that even though 1 month time was granted by the trial court to the plaintiff to deposit a sum of rupees 1500, this was not done. This again is a finding contrary to the materials on record. There can be no quarrel with the proposition that in a suit for specific performance of the contract, the plaintiff must prove that he was ready and willing to perform his part of the contract continuously between the date of the contract and the date of hearing of the suit. But the finding that the plaintiff has not proved his capacity to perform his part of the contract, as he was not even ready to deposit the money in terms of the trial court's order, is factually wrong. It appears that no such plea was raised by the defendant before the first appellate court. In the memorandum of appeal filed before the High Court in the second appeal also, there was no such plea taken. On perusal of the records, it appears that the deposit was made on 19/12/1978. That was well within 1 month time granted by the trial court by its judgment and decree dated 25/11/1978. Confusion appears to have arisen because, notwithstanding the deposit, an application for extension of time was filed. The High Court should have ignored the application and should not have put any emphasis thereon, as verification of the records would have revealed that the payment had been made. Let us now examine whether a contractor engaged to execute a particular work can file a suit for accounts against the employer in regard to payment for the work done. Such a right is not created or recognized by any statute. The independent contractor is not an agent of the employer, nor is the employer in the position of a trustee with reference to the independent contractor. Can the claim be supported in equity by stating that where the relationship is such that rendition of accounts is the only relief which will enable the contractor to satisfactorily assert his legal right? A contractor who is engaged to execute a work is expected to maintain his own accounts. At all events, there is no bar for a contractor to keep an account of the work done, even where the contract between the employer and independent contractor may provide for payment on the basis of measurements to be recorded by the employer. Nothing prevents the contractor from measuring the work done by him and then suing for the value of the work done. The contractor may also demand joint measurements to determine the quantum of work done. If the employer, for some reason, does not cooperate or prevents the contractor from taking a physical measurements, the contractor can seek appropriate legal remedy which will enable him to take measurements or to secure the information from the measurement book in the custody of the employer. Therefore, either the fact that the measurement book is maintained by the employer or the fact that the contractor does not possess the exact measurements will not entitle the contractor to file a suit for rendition of accounts against the employer. A careful reading of section 149 shows that it would apply only in respect of the court fee payable at the time of institution of the suit. If the court fee due on the plaintiff when instituted is not paid wholly or partly by the person instituting the suit, the court in its discretion may allow him to pay the court fee of deficit court fee within the period fixed by it. Source is 3P Legal rhc10, exercise number 10, and words are 820. Speed is 100.